morning, everybody. Are we ready to start? We are. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting prior to an executive session or the next meeting thereafter. Just for everybody's knowledge, an executive meeting will be held today, April 9, 2025, immediately following this session to review matters that are by statute confidential, which includes the review of completed investigations for the purpose of issuing final adjudications and administrative matters. Let's start with a roll call here. Commissioner Reddycliffe. Here. Commissioner Parcells. Here. Commissioner Caruso. Here. Commissioner McKee-Vassallo.
Here.
And I am present, so all of the sitting commissioners are present here today. First order of business is the, let me also offer an opening statement on public comment. This is our official meeting for public comment, although we welcome it at any meeting. Pursuant to the Public Official Employee Ethics Act, Act 170 of 1978, as amended by Act 9 of 1989 of June 26, 1989, and as amended by Act 93 of 1998, the State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individuals subject to provisions of the Act and from other interested persons. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony of said individuals pursuant to the law. As our previously published notice has indicated, the Commission will request copies of any statement that is presented. The individual presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. With that, our first item of business is the minutes of the January 8th, 2025 meeting. They have been distributed. Has everyone had a chance to review them? If so, I see that they are partially redacted in part on my end because I recused myself from the matter involving Catalyst Experiential because that is a matter in which my law firm and myself had representation. So I am going to recuse from approving that section of the minutes. But do I have a motion to approve the minutes unless there are any changes that are suggested?
Second.
Okay, moved and seconded. Any changes or any comments about those minutes? All in favor?
Aye.
And I, with the exception of the Catalyst matter that is blacked out in my copy, so I don't even know what it says. Although I guess it's going to be public, so I'll read it afterwards. With that said, our agenda, we have some consent defaults, and then we're going to be speaking for those in the audience for an exciting topic. It actually is exciting topic about a step in the process of our regulation discussion. So we just have a few matters before we get to that topic. With respect to a civil penalty consent, Commissioner McKee-Vassallo, can you present that?
Yes, thank you, Mr. Chair. There is one civil penalty case with a proposed consent agreement for our consideration today. This case involves respondent Eric Altman, a constable, deputy constable, who failed to timely file a statement of financial interest for calendar year 2023. The parties have submitted a consent agreement proposing that the commission find that the respondent failed to timely file an SFI for the year stated and impose the civil penalty that I will detail in my motion. Respondent has now filed his delinquent SFI for calendar year 2023. Based upon my review of the facts, I am of the opinion that the consent agreement is a proper disposition for the case. It is my opinion that the Commission should impose the civil penalty agreed to by the parties per the consent agreement. There's nothing of record that would constitute a defense or excuse for noncompliance in this case. So based upon my analysis and the comments I just made, I would like to make the following motion. I move that this Commission approve the consent agreement submitted by the parties imposing a $150 civil penalty against respondent Eric Altman for failing to timely file a statement of financial interest for the calendar year 2023. I further move that to the extent that the respondent has not already done so, respondent shall be ordered to pay the recommended civil penalty amount agreed to by the parties per the consent agreement within 30 days of the issuance of this Commission's order. That is my motion.
Is there a second?
Second.
Are there any questions or comments? All in favor, say aye.
Aye.
Aye. Any opposed? Motion carries. There is a series of, I believe, 4 civil penalty defaults. Commissioner Caruso?
Thank you, Mr. Chairman. 4 civil penalty default cases are now before the Commission for decision. The respondents involved in these cases will be identified individually in the motion I will be making regarding these cases. These respondents failed to file statements of financial interest for calendar years that I will detail in my motion. The respondents did not take any action or otherwise respond to the civil penalty proceedings. Following review, it is my opinion that as to each respondent, the Commission should levy a maximum civil penalty for each delinquent statement of financial interest. It is my opinion that the Commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their noncompliance with the requirements of the Ethics Act. Based upon my analysis and comments, I would like to make the following motion. I move that this Commission levy maximum civil penalties against the respondents in these 4 civil penalty default cases as follows. For the first case, I move that this Commission levy a maximum civil penalty in the total amount of $250 against respondent Raymond Stanley for failing to file a statement of financial interest for calendar year 2021. For the next 2 cases, I move that this Commission levy a maximum civil penalty in the total amount of $250 against each respondent for failing to file a statement of financial interest for calendar year 2022. China Pendleton and Jack Fetcher. For the remaining case, I move that this Commission levy a maximum civil penalty in the total amount of $250 against respondent Brian Gerber for failing to file a statement of financial interest for calendar year 2023. Further, these respondents shall be ordered to file complete and accurate statements of financial interest for the years stated within 30 days of issuance of the Commission's order. That is my motion.
Is there a second?
Second.
Any questions, comments? Hearing none, all in favor?
Aye.
Aye. Any opposed? Motion carries. Let's move to regulations. Ms. Guilfoyle.
Yes, Executive Director Mary Fox has agreed to handle a technical aspect of today's discussion, and Deputy Chief Counsel Martin Harder has agreed to act as the scrivener as long as I called him a scrivener. So that has been accomplished. So the first thing, I wanted to make just a couple of introductory remarks. So everyone is aware that we have been working on revisions to our regulations. Last year in April of 2024, a significant number of technical regulations were promulgated after going through the streamlined final omitted rulemaking process. So after we had identified the technical changes that the Commission wanted to make, the regulation working group, which consisted of Chair Schwartz, Commissioner Caruso, Executive Director Fox, and the legal staff here at the Commission, began working on some more substantive changes that the commission wanted to see made. And so after we put together some changes, we had a list of substantive changes and we put that on an agenda, and you'll recall you hosted a number of interested parties at your June 18th, 2024 meeting, and there was a robust discussion of regulatory topics at that time. So after hearing those comments and gathering all of the information from the working group into an organized list, I began incorporating them into a draft version of the regulations. When necessary, I researched not only case law and relevant statutes, but other jurisdictions, ethics laws, and regulations. I even went to an opinion from the American Bar Association on one thing, and so on. The draft version of the regulations in the format that is required by the Independent Regulatory Review Commission is in your materials with the changes in red, so they're easier to identify, even though I'm sure with the brackets and underlines it makes it a little bit difficult. The preamble, which accompanied the draft regulations, is the document that puts it into a summary format of the each change and the reason why it's being changed, or the basis for the change. So what I want to do today is I want to go through the regulations, the draft version, and make sure that all of the changes that I have in here are something that the commission approves of. If there's anything that needs to be discussed, that we discuss it. And if there's any additional changes that people that were not in the working group would like to see changed, I think this would be a great time, for those that were not on the committee to bring those changes up, and we can discuss and maybe incorporate some of those as well. So after this discussion today, what I'm hoping to get from the commission is I would like to see a motion to approve the sending out of what I call the exposure draft, which is what you have in front of you, which would be sent out to all interested stakeholders, not as part of the formal public comment process, but this is a way to gather comments and hopefully get a consensus from all of our interested stakeholders before we start getting into the proposed rulemaking, where it has to be presented to ERC, the Attorney General, the General Assembly, and when comments from that portion have to be tracked and sent to everyone. So I'm hoping that that is where we are at the end of today. What I'm going to do, and I hope you'll bear with me because it's an interesting project to try to organize when there are so many changes. So what I did was I put together a very rudimentary PowerPoint, it's only 11 slides, to introduce the topics that were of a significant change in each chapter. So that way when we start looking at the chapters in depth, that these are the more significant changes that we are proposing to be made. I also have a list of what I call a list of the no's, where we had talked about possibly changing something, and for some reason, after I researched, I found out that we couldn't make that change, or I was not recommending that we make that change for some reason. And I would like to, it's a relatively short list, but I think that it is necessary to go through, especially for the working group members who would be wondering what happened to that, that particular change. And then lastly, we can review the annex, which is the language of the regulations, what I call the draft version, and decide what changes are okay, what needs to be tweaked a little bit, anything that needs to be added or deleted, and we'll go through it in that way. That was the best that I could do in coming up with a way to organize this. So with that, the PowerPoint, if we can move on to slide 2. So slide 2 talks about the oh, that's small. Can everybody see? I apologize for the font. I hope it's not just me.
So we're having a little bit of technical difficulties with this PowerPoint, but if we can, Sean, if you can go to the bottom right-hand corner where the plus is and expand it a little bit, it should be better, easier to read.
Also, just put it in display mode if you took that top, the second button from current slide.
I tried that a few minutes ago and the PowerPoint crashed on me, so.
Okay, and let's just do it like this.
Technology is not my strong suit. So the chapter 11 has some fairly significant changes. We added a lot of definitions, including we added definitions of all of the different divisions within the commission, as well as a definition for executive director and for chief counsel, primarily to address any issue that we would have with bifurcation or the Linus case. We are proposing an update to a definition of the burden of proof. We are updating definitions of de minimis economic impact and gross negligence, and I'll explain, where we got the proposed language from when we get to it. We are also adding a definition of private pecuniary benefit, which I think is something that we really, really need. This got a little confusing. The wrongful use proceedings were identifying individuals as respondent and complainant. It got a little bit confusing because the roles are reversed in a wrongful use proceeding, so I wanted to do something that would make sure that everyone is aware of which individual we're speaking of. So we added definitions pertaining to those. We are removing the judicial officers and employees from the definitions of public employer and public official based upon a court case. We are revising the definition of sworn complaint to remove the requirement that it be notarized in favor of the language that it be signed under penalty of perjury. Next slide, Sean. Thank you. That was it for chapter 11. Chapter 13 is the opinion and advice of counsel chapter. There's a few notable things in here. We are modifying the time period for filing a reconsideration request, a petition to intervene, and an amicus brief. We are adding the Commission's website as a location where Commission opinions and advices of counsel can be found. And we are deleting the language about publishing an annual digest of opinions and advices since they are located on the Commission's website.
Thank you.
Next slide, Sean. See, these are the ones that are easy to go with. The statement of financial interests in terms of applicability, which is chapter 15, the only significant change is we are adding third-party professional services providers to those who are responsible for filing an SFI, a statement of financial interest, basically to comply or coordinate with an earlier act signed by the governor. Next slide, Sean. Chapter 17 continues with statement of financial interests. This deals with the content. We are consolidating some of the familial designations under basically the statutory definition of immediate family rather than list them all, since we already have a statutory definition for it. And we're adding nonprofit organizations to the reporting requirement under the office directorship or employment section. Next slide, Sean. Another small one, the statement of financial interest under the miscellaneous, chapter 19. It is delineating the responsibilities of the newly defined administrative division, executive director, and investigative division in the SFI filing process and the civil penalty process. Again, so everyone is aware that we're taking away just the generic commission and we're inserting these different divisions or individuals as the person responsible for doing that particular job. The next slide, Sean. This is where we get into the most significant changes that we're making is chapter 21, which is the investigations section, and it actually includes the hearing section as well. Again, in keeping with what we were just talking about, it's again delineating the responsibilities of each division or individual. It deletes disclosure of a complaint as a basis for wrongful use of the Ethics Act. Again, that's based on a court opinion. It is removing the legal division from the investigative subpoena process to, again, comply with the bifurcation issue. And it requires a subpoena to be accompanied by an advice of rights form for everyone. Next slide, Sean. We are establishing a basic good cause standard for various extension requests, rather than, we had some differing language, extraordinary circumstances, some other things. I think the good cause standard is the way that we should probably go. It sets forth notification of default for failing to file an answer to the findings report. And before anyone has any great objection, I included this just as a discussion point. It allows the commission to designate the chief counsel as a presiding officer for a hearing if need be. It sets the procedure and timeframes for turning over evidence to a respondent in a case. And it changes hearing officer to presiding officer, and it also deletes several administrative responsibilities for the presiding officer, including, there was everything in there from, getting costs for witnesses reimbursed was the responsibility of the then hearing officer. So we're removing some of those administrative tasks and putting them more in line with where they actually occur. Next slide, Sean. The one thing that we did not have is a defined procedure for requesting hearing subpoenas and including what information was necessary in order to justify the issuance of a subpoena for a hearing. So we've included a procedure for that. As we talked about at the last meeting, we added a section on treble damages to be consistent with the commission's resolution in terms of what it considers when determining whether to impose treble damages. And it basically does a complete we're also proposing almost a complete revision of the section on the reconsideration process to address the court's concerns in the Seropian case. Next slide. Chapter 23 is the commission, the general provisions. We added some guidelines for items that need to be included in meeting minutes, so everything is consistent. We are clarifying some of the prohibited activities of the commissioners, and we've added a section setting forth a party's right to raise a potential conflict of a commissioner and how they do that. And the last slide, Sean, is the wrongful use section or chapter. Again, it deletes public disclosure, has a basis. It, again, clarifies the identities of the parties to avoid confusion. It outlines the investigative procedure for a wrongful act proceeding. And again, it delineates the responsibilities of the investigative division, executive director, and the commission in a wrongful use of act proceeding. So those are the big, what I would say are the big ticket items for all of the changes that are being proposed. There are some things that the working committee wanted to include, and I decided based upon research that we could not do it. And if I could, I need to get we wanted to delete section 13.5B B relating to access of opinions and advices where we send them to, literally, I believe Sean puts them on a disk and sends them to various organizations, professional groups, libraries, et cetera. We can't delete it because it's actually in the act as well. We were going to amend section 15.3E and F concerning candidates and nominees. We were going to align it with certain legislation. That legislation is still pending, so I don't recommend changing that at this point. And this was something that everyone wanted to change throughout the regulations, which was changing mostly when it said the commission will do something, the commission will, the committee wanted to change it to shall. The will shall issue is actually directly addressed in the style manual. And we can't change it because according to the style manual, the word shall expresses a duty or obligation. The subject of the sentence must be a person, committee, or other non-governmental entity. So the word will, according to the style manual, indicates that the Commonwealth pledges to act. So that's the reason why throughout the regulations it says will and not shall. And we can't change it. Well, we can try to change it. It would come back if we did. In 21.3, there was a recommendation that we change, this is in the investigative section under preliminary inquiries. There was 21.3D, they wanted to change to the commission, the ID, and the executive director will. I don't believe that we should do that based upon line S. What I'm recommending is that it be changed simply to executive director. There was a suggestion for 21.5 about adding a section about delegation to deputy executive director, and I didn't change that since that position no longer is in existence in our agency. Just a couple more things. I'm not sure why, and I went back through all of my notes, and I will say the one thing that I did learn through this process is next time I will have somebody else taking notes while we do these meetings, because in taking the notes, I believe that I missed a lot of the conversation because I was focused on making sure that everything was written down. And so some things I had to go back to notes, or I was asking Martin about what is the reason that we're doing this. 21.27 is the briefing section, and the suggestion was to remove the language which will be in conformity with 1 PA Code Chapter 35 relating to formal proceedings. I'm not sure why that was recommended that we remove it. There's no harm in leaving it, and under 1 PA Code Chapter 35 relating to the formal proceedings and briefs, it's essentially saying that they have the same basic obligation or rights to file a brief, who files first, a reply brief, etc. So I'm not sure why that was recommended, but I would say that we leave it as is. This one, Martin and I spoke about extensively. Under 23.6, the suggestion was made that we wanted to give the commission the authority to grant permission to an individual to review executive minutes. In the talking with Martin and we could not come up with any instance where that would be a good idea. We came up with a boatload of reasons why we shouldn't do it, and, you know, including obviously confidentiality issues and the ability of commission members to speak freely in executive session, et cetera. So I did not include the permission to review executive minutes. I just, from a legal perspective, it seems like it could be a big problem going forward. The two more things. One was that we wanted to define the term close friends in, I did a lot of research on this. It's an interesting topic and one that has come up in other jurisdictions. I always tend to look at our sister states and some of our border states, as I would call them, and some of the larger states. It's all over the place in nobody has a definition for the term close friends. I actually found a formal opinion from the American Bar Association on ethics and professional responsibility, where they discussed the fact that there are so many different types of friendship. Everything from, you know, someone that you would consider one of your best friends versus somebody that's a Facebook friend. You know, there's such a differing level, and everybody has a different perspective of who they consider a friend or a close friend. And the opinion from the ABA was basically, and I agree with it, is to let, the best practice would be, instead of defining the word close friends, let's just take out the word close and go with friends. And then ultimately, the best practice would be if you have a situation where someone that you consider a friend of any type coming before us, to disclose that information, and then there can be a discussion about whether to recuse or not from that proceeding. Because again, a Facebook friend, everybody knows that a lot of people that you're friends with on Facebook, you're not really friends with. So, I mean, there are people on there that I'm not even sure that I actually know. But the last thing that I want to bring up is something that Chair Schwartz raised as a potential change to 23.7 pertaining to the election of the chair and the vice chair. Chair Schwartz, do you recall you and I discussed this briefly after you returned from Kogel concerning the.
Oh, yes.
And you and I had a discussion, and I explained, you know, some of the reasons that I was hesitant. The suggestion was, and please interrupt or add anything to this that you want. The suggestion was that the officers for the commission should be from different political party affiliation of the appointing authority.
Correct.
Okay.
Or given that the governor, the way that we're constituted, the governor has to appoint someone who is registered from the party opposite the governor. Either that or someone from an appointing authority opposite of the person in office, so that we would have someone appointed by a Democrat, someone appointed by a Republican, or one of the governor's opposite party appointees.
So this was probably the topic that generated the most discussion in the legal division. We talked about it quite a bit. And there are, first of all, I did do a lot of research into this as well through our sister states, and what I was able to find is not anyone that does it in that manner. The only two states that have something close to us or close to that suggestion would be New Jersey and California. And in both of those states, the governor appoints the chair. So everybody else had a members-elect with no restriction on political party or appointing authority as the officers for their commission. My concerns, and I think I, mentioned all of these to you, Chair, is number one, I think this is a solution in search of a problem that we've never had. I don't believe that anyone has ever brought this up as an issue or that there.
If I may interrupt, when I came on board, I made a similar suggestion and everybody resigned. Not everybody, but half the commission resigned when I suggested that somebody should be from the opposite party. So it has been an issue, but I'm comfortable with the commission electing. I mean, I think we police ourselves. Now, commission after us may not, but I'm comfortable where we are.
Yeah, I mean, we want the best people in these positions, not necessarily just who's next in line, and of course, we do have a history of that issue. When we were electing officers a year and a half or so ago, or 2 years ago, when it was based on seniority, or that was the thought that it was based on seniority. And so I think this is similar, setting us up for a similar issue. Again, maybe not now, but maybe in the future that it might set us up for a similar issue. And it also, in some ways, depending on the makeup of the commission at that time, there wouldn't even be a need for an election at some point because we know who the next person would be moving into that position. And I don't recommend that you take that out of your hands. I think that you should leave that decision to the membership. And and other things that Martin and I discussed. What if no one is from a certain appointing authority is interested in doing it, and we're making an apolitical body somewhat political, and I'm not sure that we need to do that. So I did not include that in the proposal, but I wanted to put it out there, and I wanted Chair Schwartz to have an opportunity to address that issue.
Any other things that we discussed that haven't been raised? No?
Okay.
So let me suggest this. That's very helpful, Bridget, and I think really, really good. I think from all of our perspectives, from a level setting, we want to get input from each commissioner of what do you think. Our goal today is not to come up with what we're all comfortable with as a final product. We're not voting on this is the commission's final approved regulations. We're trying to get something that we're comfortable as the commission as a draft proposal so that we can get comments from all constituents out there that we will then all consider those comments, incorporate, including us thinking more about the draft and including our own comments, getting the feedback of IRC and everybody else, and going through the process to get our final views. If we're all comfortable that we can come up with a draft that is ready to go out, recognizing we have to be comfortable with the draft, but not necessarily it as the final product. Bridget raised one comment out there that we had a lot of debate, whether or not the role of hearing officer should be potentially delegated to a non-commissioner in the chief counsel if we ran into problems where a commissioner was not available, we had timing issues. That's something to think about. This issue, I'll just throw out there because Bridget raised, I think Commissioner Purcell's is right. Historically, I think the commission at different times have had officers go by seniority or think that there was a seniority system. I think some of us thought that there was not a seniority system. It's certainly not in our statute. There are some commissions that it is in the statute. And I think we've been operating under a system where we've decided on our own who merits the position. We are political appointees, and our statute actually sets it up that we come from the caucuses, the 4 caucuses, and the governor who has to appoint someone of the opposite party. So I do think we can't ignore the fact that we intentionally were set up to be representatives of a diverse set of political group, but I think we have all understood our job is to try to get together and work together and look after the public ethics that I think we've operated well together. The idea came from, because I think we work so well together, and in part, we've worked in the last, has it been a year and a half or so, with a chair and vice chair of opposite political party appointing authorities, and maybe that has helped us in some ways. But I think, Bridget, your point is well taken, and I think your concern is maybe we should just think about that when we're deciding that maybe that should not be dispositive and written into a regulation. The other thing, and I think we heard this in feedback when we were doing our technical regulations, I think we should be very cognizant that when we're doing regulations, our job is not to legislate. We're not recreating the Ethics Act. What we really are doing is coming up with procedures to carry out our responsibilities. And many of the proposed procedures here are actually incorporating judicial opinions, legislative changes, and incorporating them into regulations that have not been reformed, revised in many, many years. Others are to kind of implement procedures that we have come to believe are necessary and ways to operate efficiently based on how we've seen matters move forward. So I think there's been a lot of work done. It may not be perfect. I think everybody probably has some good ideas and suggestions. And I would suggest just let's go one by one and just offer, if anybody has thoughts, issues, concerns, let's just throw them out there. And if I can ask Martin and Bridget to take that all in, because we may want to have some of this revised as part of what we want to put out as a initial, what is it called?
Exposure draft.
Exposure draft. How would we like to start? Does anyone want to go first?
Yes,
Mary has some suggestions.
Yes,
I have 2 suggestions.
go ahead.
And I think they're both important. Section 21.28A, treble damages.
Yes.
I believe that we have omitted one of the statutory use of office confidential information as one of the prongs for a conflict of interest under the Ethics Act. So specifically, it's subsection 2, where we reference a use of office or the authority of office. I think it also needs to say or confidential information obtained through the use of office, because that is in the statute.
Does that make sense to
Yeah, it does
everybody?
make sense, yes.
Everybody comfortable with that addition? Seeing kind of a consensus, let's amend that as at least the suggestion here. That's a very good one. Thank you.
And my second suggestion would be Under section 23.5, records of meetings, we created a subsection B delineating what the public and executive meeting minutes must include. And I think we're missing one item, which would be when we have recusals of a commissioner or potentially even the executive director or others from the agency recused from a particular matter. We had received feedback in the past from the public that we should be putting on the record why people are recusing. And so I would like to add a subparagraph under B that states something like recusals and reasons for such recusals.
Good
Yeah,
point.
I like it.
Do we have consensus on that?
Yeah, that makes sense. I also had a question about that provision though. I don't know if you're done.
I'm done.
Okay. Are we okay including records of executive meetings in this delineation?
Yeah, I had the
I
same
would-
question.
I'd be much more comfortable just dictating what must be in public meeting minutes. I also have not looked at what sunshine requires for executive sessions, but I don't wanna hamstring ourselves.
So this entire discussion, if I recall correctly, began because of executive minutes. And we weren't even really talking about public meeting minutes at the time. We were talking about, again, the potential of allowing somebody to view executive minutes. And that sort of evolved into, well, shouldn't we have something in here which says what should be included in our executive and our public meeting minutes? So that was why that was in there. I'm more than happy to take it out if the commission is uncomfortable with that.
So aren't we governed though by Sunshine Act and what we must actually maintain? It's like, if there's already something out there that tells us what we have to maintain, we shouldn't be opining on what we will maintain.
I don't think that the Sunshine Act, I mean, there are some things that are governed by the Sunshine Act. But I'm yeah, I was just
think we
gonna
need to
say-
go back and look to make sure that we're not taking on a burden that we don't have and opening ourselves up to potential challenge in a way that we weren't anticipating. For very, benevolent reasons, we wanna have the information out in the open and that's consistent with who we are. But if there's law out there that governs what we need to do, we need to be careful.
For some reason, I did not think that it specifically stated what information needed to be included.
And I could be wrong, so I would like to, I may be.
No, but I think that's a good point. Let me suggest this, Bridget.
Okay.
Mary's point about recusal, I think, has consensus to add. With the contingent, please look at the Sunshine Act and it should be modified and included in line with any requirements of the Sunshine Act.
Could I also suggest that we take a look at Robert's rules? I believe there might be a section in there that references what's recommended to be contained.
Yeah, I went through Robert's rules and did locate some information, but I did not think that it was all encompassing. So I will look at both again, just to make sure. I think the idea was just for consistency at this point, so that all of our meeting minutes have and of course, when Julie Gibson does them, they all have a consistent theme to them, but going forward, want to make sure that that continues. So I will look at the Sunshine Act as well as Robert's Rules again and see if there's anything in there that would need to be modified based upon either one of those.
Thank you. Why don't we go commissioner by commissioner? Have you finished?
Yes, I have.
Okay.
Do you want me to keep going?
Would you like to keep
Chair,
going?
since I've already jumped in,
Yes.
as eager as I always am.
Which is always fine.
So on the hearing officer issue,
Yes.
I do think it's important that we have the power to designate a hearing officer. I wonder if we're looking for flexibility, right? Last minute recusal issues, unavailability, Are we hamstringing ourselves or not giving ourselves enough flexibility by only identifying to whom it can be designated, because you could conceive of a circumstance where we would actually hire somebody to serve as a hearing officer as other commissions or boards do. And that would be a very different process than what's been used previously. But if we only designate it to one person, are we gonna be coming back in 5 years and saying, this isn't going to work because the chief counsel has a similar conflict? So I would prefer to have something broader than just one individual, understanding that we do have the issue of the separation of powers between the two divisions.
If I may, Commissioner, just for a point of reference, I'm aware that the Office of General Counsel does have a hearing officer contract where they have professional hearing officers on that contract available for use by state agencies. We would need to check to see if it was available for our use, but it does exist.
Yeah, I used to, actually, I was an administrative judge under the Office of General Counsel, so they do have, and the Department of State houses a great number of hearing officers who hear cases outside of that department.
So if we're looking for flexibility, we should see what the actual flexibility can be.
I agree, and that's one of the items that I have listed, and just maybe indicating or their designee, the chief counsel's designee. I mean, could it be the assistant chief counsel? I was very concerned about that very issue as well.
When we first started talking about this, and I think the reason that I landed on just me, or just this position, our former chair was the one who made that suggestion. When we were first, this was going back, a quite some time, when we first started talking about this issue, and it was our chair at the time, Shelley Sims, who mentioned that she would only be comfortable if it was designated to the chief counsel. So that's sort of how I ended up doing it this way, and knowing that people were hesitant even to possibly delegate it to anyone. And like I said, Shelley was, I think, in the minority when she said she would agree to it, but only if it was just the chief counsel. That's where that came from. Not that I'm trying to make it a just for something that I would do.
I mean, I just agree with you that I don't want to box ourselves in and find, that we come to a hearing and all of a sudden you're unavailable because you're out for 3 weeks with a broken leg or something, or.
Not that he wishes that
Not
upon
that I wish that on.
Thank you, Dave.
Or-
I appreciate that.
And then all of a sudden we have to delay things unnecessarily.
Let me ask so the language we have right now, and I'm not sure whether it's contradictory or not. If you look at 2121B, hearings will be conducted before one or more members of the commission. That's how it exists now. And then it says the commission may, the way it reads now, appoint a hearing officer for the conduct of the hearings. So it starts with the will be conducted, but then says they may appoint. Now, it's not clear that hearing officer, whether it's a member of the commission or it is someone other than a member of the commission. Maybe what we can say, you have suggested adding, may designate its chief counsel. Can it say may designate its chief counsel or appoint another person as the hearing officer? And that essentially is explicitly allowing the commission to delegate that role. And we can get feedback on that point. And we can all consider that point. And this way, it raises the question. The one thing I would ask, I think I had raised, there is percolating in the courts had challenged the Philadelphia School District, or previously the School Reform Commission, had designated hearing officers to conduct charter non-renewal or charter revocation hearings. And
So my firm is involved in that litigation, so I wanna be careful about
Yeah.
what we talk about
Yes.
with that and make that clear on the record that I am
Under-
involved in that litigation.
Understood. All my point, I don't think this is a conflict. I'd like to see, I don't know whether they were challenging the authority of the hearing officer in those cases. The hearing officer, which was not from your firm, was Rudy Garcia. And I thought that there was a challenge to the authority of the hearing officer. So I just would ask that we look at that litigation from a legal matter, because that may also, now that was not someone from OGC, but it may have been a contract person as opposed to a state employee. So we should just look at that if we're thinking about this regulation in that way. It may be the simplest is leaving it as a commissioner, but I know we're thinking about flexibility. Other,
I have one other point and then
yes,
I will.
please.
On private pecuniary interest,
You
which
remind
is
us
on-
what section?
it's in the definitions,
Definitions.
so it's page 68 of the PDF. We say a financially related personal gain related to the receipt of actual payment or the avoidance of a loss or expense. How does that cover gifts? Are gifts considered payments?
I think anything received of value would be. I mean, it's,
Yeah, that should be clear, I agree.
I'm also reading this in somewhat of a vacuum, right? Because do we define payment?
that would be probably the place if we wanna start defining exactly what payment means. So our definition of private pecuniary benefit, this definition was taken in part from a court opinion and in part from one of the cases that we had in front of the commission.
But I think this is a good point about the word payment. I know we had a case before us that we decided about the avoidance of a loss or
Yeah, I got that.
expense, and that was something we wanted to make clear. Clearly, under the Commonwealth Court's opinions, it has to be financially related.
Yeah.
So private pecuniary gain cannot be a political advantage or
Right.
something that is personal but not financial. But I think it's a good point, is payment too restrictive? Should the word be the receipt of something of value?
Thinking of the FCPA context,
Yeah.
it's beyond payments.
Right, so would it be the receipt of something of value, and something of value is modified by the word financially related? Is that a better way of defining it? 'Cause it still would say a financially related personal gain related to the receipt of something of value or the avoidance of a loss or expense.
Better.
Should you put de minimis in there too, beyond de minimis?
Well, we have de minimis,
Yeah.
though, we
Yeah.
define de minimis separately.
I also have concerns with regard to this definition. I figured it would kind of flush it out with the regulatory process, but I have concerns about the reference to financially related or personal gain, because I'm concerned that this definition could be in conflict with some of the Supreme Court case decisions involving the Rendell decision. I don't know that this is consistent with that decision where the Supreme Court said that the pecuniary gain going to a nonprofit on which the spouse of a public official serves could form the basis for a conflict of interest under the Ethics Act. So I'm worried that putting the word personal in that is going to gut the way that we're able to proceed in investigations.
Bridget, what's your thought on that?
I mean, I think that we could probably get by with a financially related gain. I think that's a financially related gain, if we don't modify that with something, a financially related gain to who? Financial, who got the financial gain? I think we need to have something we have to have some sort of modifier that explains who received the gain.
I would recommend we just track the statutory language that says to the public
Yeah.
official, public employee, member of their immediate family or business in which
with,
they are.
you know, that's,
Yeah, and track the statutory language. It's long, but
yes.
it's what's in the statute.
Let me suggest this. Why don't, for this, I think the point about payment is a good one. I think we should do that as something of value. And I do think, I'd ask that we go back to the cases in the law to see whether personal is too narrow and whether we need to broaden that. And I guess with respect to these two issues that we've identified so far, there may be others. What we'll do at the end is, for the exposure draft, it will be subject to the modifications that we've asked you to do, that are, approval to send out an exposure draft will be subject to the modifications that we've, been discussing since it's going to be in that preliminary stage. Was that
That's
all of
I
your
have.
comments? Why don't we just go down the line? Can I ask you, Commissioner Reddy-Cliff?
I would just say that the new definition of clear and convincing proof and the gross negligence under the 11.1 definitions are well done. I think they're clear and, did you come up with this language?
Dave, don't give me that much credit.
It just, I didn't know if that was something that is, that you got from another state or?
No, clear and convincing comes directly from case law here in
Okay.
Pennsylvania. And the gross negligence is a combo of the standard set of jury instructions and of case law. Because there's a great deal of conflict as to what a definition of gross negligence is. There's a lot of cases out there. It's very difficult to get a handle on a definition, and nearly every court case I've looked at indicates that as well, when they're trying to figure out what is gross negligence or what the definition would be. So that's where that particular definition, like I said, is a combo from the jury instructions and case law.
No, from my perspective, it's good language, and I'm hoping others agree with it. Under public employee, in the same section, go down to Roman numeral 5A, city clerks, other clerical staff, we're removing roadmasters, keeping in secretaries, police officers, maintenance workers, construction workers, keeping an equipment operator, taking out recreation directors. It seems like why are we taking out roadmasters and recreation directors, but keeping in equipment operators? And, on the one hand, it seems like we're trying to make it broad, but on the other hand, are we inclusive enough in that definition?
Can I respond to that one?
Yes.
Yes, would you? All right.
No, because my answer was going to be, this is one of those instances in which I wish that I had been, instead of taking notes, that I would have been listening to
That's all
what was
right.
going on,
That's
because
all
I
right.
don't know why we're removing.
Yeah, I think the origination that may have come, or the request to remove those two sections may have come from someone on my team, or maybe even me. So the reason that we wanted to remove both the recreation directors and roadmasters is because if you look, we're saying that these are people who are generally not considered public employees. And when we've had cases in the past involving roadmasters and involving recreation directors, it appears in a lot of instances these folks have discretion over how money is spent. And because of that, generally those types of positions are gonna be falling under the definition of public employee. And it gets really difficult when we have a reg saying generally a roadmaster is not covered, but their job duties show that they can do all of these things that bring them within the definition.
I get that, but then you would think that a recreation director would have more responsibility than the equipment operator. And my only job is to go out on the backhoe.
They do.
This is the ones that are not
They're gonna be
considered.
placed into the definition of a public official, so they'll
Yeah.
now be within our duty. I had the same question, it didn't make sense to me,
Yeah,
but
it's-
now we're increasing the people who have to file. Recreation directors and roadmasters would now have to file SFIs. Because if you go up, these people are not considered public employees, so by deleting them, we're now making them
Okay,
public.
gotcha.
So I had
I
the
was-
same.
All right. All right, well, I see that now.
I mean, I suppose there's instances where these folks still might not be public officials or public
Right.
employees, but we need to know what they can do in order to know for sure.
All right. Well, I just didn't want it to have it look willy-nilly that, we have certain people in, certain people out. And I didn't know if there was a broader class for local government folks. I don't know.
And I think in the preamble that I did discuss that the reason they were taken out, and I have no idea where I got this, but that they were removed because sometimes their job duties would in fact fall within the definition of public employee, so.
Yeah, and we've had a number of cases
Yeah.
of roadmasters who are actually have a lot of authority to
Yes.
hire, fire,
Oh,
and
yes.
spend money.
Oh, I
Which is why so many supervisors appoint themselves roadmasters.
Right.
We have had those cases and may even have a couple of those cases coming up.
All right, heading to 19.3. And this goes to an earlier issue on the hearings, but 19.3B, if a complaint is received alleging that a required filing is deficient or has not been made, the commission, we're removing the language commission and inserting executive director. So my thought here is, in the paragraph before that in A, we're taking out commission and putting administrative division, so it's a group of people. In B, we're limiting it to the executive director, and I know there was a comment made, we don't have an assistant executive director. But once again, what if there was a vacancy in the an extended vacancy in the executive director's position? Does that mean things come to a standstill, or what happens?
No, so you guys had approved a policy a few meetings ago allowing Jennifer Lehman, who's currently serving as our Director of Enforcement, Litigation, and Education, to serve as an acting executive director in my absence. If she's unavailable, then it bounces to our Eastern Regional Director. So we have a waterfall sort of
Authority.
set up in terms of authority. So if I wasn't available,
So we don't need to have other language in here that says, or their designee, or not, if it's a vacancy, if it's.
There's always an acting executive director, so there's always an executive director under the authorization authorization
So does
that we
acting
approved.
executive director then fall under the executive director? That's, okay.
Yeah, and the policy allows them to step in and act on any matter in which we have, that I would be able to act on.
Okay. That's easy enough then. And then my last one is under 21.5, the conduct of investigations, removing the stenographer. I just want to make sure that's not in the law, is it? Because I know some laws actually specifically said, you have some kind of a stenographer.
I do not believe that it is.
Okay.
I think a lot of this procedure came about after the Ethics Act was enacted. These
Okay.
were the procedures that were laid out to, as regulations are often supposed to do, to implement the language of the statute.
As
So
long as it's not in.
Yeah, could you just confirm that that's not in the statute? That's a fair point.
That's all I have then, Mr. Chairman.
Thank you.
Great coming towards the end because you've answered most of my questions. And the stenographer was one that I had as well. I would like to see that verified, that that's not in the act. I did compare this work product with the act, and I think you've done a very good job, and it's a good starting point for public input.
I as well don't have anything else to add. I thought when we were going through this, that when we were hammering out things during our sessions, that we had hit it, hit it pretty closely. And now seeing all these different comments, it sees what you can miss. But I agree with what everyone else is saying.
Yeah, I actually used to love doing this when I was in the legislature, but you did a good job.
I know we have public comment later, but I know we're talking regulations. I'm not going to call on anyone, but I'm certainly happy to open the floor if anyone would like to comment on this particular topic at this time. Not hearing anything, we'll move on. So I'd like to make a motion subject to the comments and the questions that we've asked Chief Counsel to look into. I would move that with the revisions and the comments we've made, that we authorize Chief Counsel and our Executive Director to submit this as a, what's it called?
exposure draft.
Exposure draft to start the regulatory process, recognizing none of us are specifically affirming that this is our final regulations, and everybody's reserving the right to make further comments, take a position on particular regulations when we later have to vote on whether or not this is the regulations we want to adopt. But starting the process of moving it forward, I would move that the set of regulations draft as presented and as modified in today's discussion be released as an exposure draft. Do I have a second to that motion?
Second.
Any discussion about that motion? Hearing none, all in favor? Aye. Any opposed? Motion carries. Thank you very much. This is terrific work. I know Bridget, Martin, thank you for all the hard work getting here. We still have a lot more to do.
And also thank all of you who served in the working group as well. None of this would have come about if not for everyone's comments and suggestions during that process.
So Mary, we have a number of administrative matters to cover, please.
Yes, thank you. If I may take these slightly out of order, I think it makes more logistical sense if I start with the operational report.
Go ahead.
Thank you. And I want to point out, I do have a typographical error in this operational report. Under the budget for fiscal year 2024-25, I have noted these are the numbers as of December 2nd, 2024. They're actually the numbers as of February 28th, 2025, so they're more updated than that. I have laid out our projections. We are projected to have a surplus of close to $400,000 in our fiscal year 2024-25 appropriation. I do have a proposed plan for how to spend some of that projected surplus that I think will be beneficial to this commission, but also to all of the public officials, public employees, and I'll get to that in the next item that I cover on this administrative agenda. So we also, we have done an excellent job of, utilizing in a smart way our surplus from 2023-24, which were waived over, so it allowed us to use those funds in this current fiscal year. But those are almost spent down, and then we have a continuing appropriation fund with a current balance of around $176,000. So happy to answer any questions about budget. Moving along, we've continued to do a number of external trainings that I'd like to point out to you. So far in 2025, we've conducted 12 in-person or virtual trainings. We have 11 more scheduled for 2025. They come in all the time. Requests for more trainings come in all the time. I believe we actually may have more scheduled for 2025 that have come in since I prepared this memo. But we'll continue to offer them to anybody that asks. We'll teach anybody that's willing to listen. So one thing that we started doing that we're going to duplicate again before the end of this filing season is a session called Statements of Financial Interest. Get it done right, get it done on time, where we do it virtually. It's free, open to anyone. We walk people through how to file your statement of financial interest with the idea that when they're done with that session, they're confident that they're ready to go and they can file and meet their filing obligations. We had 102 attendees. We have another one scheduled for a few weeks. Not quite as much interest, it doesn't seem, with this follow-up session, but we'll continue to offer these so people can get their filing requirements done correctly. One thing I'm particularly proud of is we have partnered with the Office of Open Records on a training that we called a Good Government Symposium, where we covered both the Ethics Act and the Right to Know law. We had 370 attendees at that, which was pretty incredible. It's something that we've talked about doing every year because we did have such a good turnout, so I'm pleased with that. We're going to look in the future about potentially offering CLE credits for attendees. Maybe that'll draw in some solicitors, which we know they're an important audience for this information. So we'll do that going forward. And then upcoming, we have been requested to provide a training on completing statements of financial interest to all the members of the Pennsylvania House of Representatives. And we're doing that on April 22nd, 2025. So we're looking forward to that. So far in 2025, we have issued 14 advisory opinions. We've opened 13 investigative cases. We have hired 2 new staff members, 2 new investigators, one of which is here in our audience today, Brittany Schmel. And then we also have Gabrielle Stahl back with us. We are currently conducting a background investigation for a position in our Western Regional Office. One other item that we're very excited about is we are going to be relocating. We're actually moving right across the hall. So our main entrance will be room 304. But we're working on the logistics of that now. We've received a lot of assistance from the Department of General Services, but we're taking over space previously occupied by the Office of Administration and the Department of Auditor General, and it allows us to expand and better work together. So we're very excited about that. Any questions on the operational report? Okay. Moving on to the SFI filing system purchase. I wanted to do this second because I wanted to mention our projected surplus. So over the years, well, as you know, we really have 2 different ways that someone can file their statement of financial interest. We have our paper form, which is also in a PDF typable version available on our website. We get a lot of people using the paper form. About 10 years ago, we created an online form. Is that about correct, Sean?
It's about 10 years.
We created an online form where filers can have the option to go on and complete their form online. If their filing location is the State Ethics Commission, they can use that and submit it directly to us, and they have met their filing requirements. If the State Ethics Commission is not their filing location, they can still use the form, they have an emailed form sent to them, and then they have to print it out and physically file it or email it to their correct filing location. It's worked very well. It has eliminated a lot of the frequent errors that we see. When people use the paper form, we see a lot of issues where there's missed blocks, missed sections on the form, and we do a lot of compliance around getting people to fix those errors and those omissions. So the electronic form sort of corrects that. But there are enhancements that we can make with regard to that form. One thing it doesn't allow you to save your form year over year. So when you go in to complete your new form, you have to start from scratch and you have to redo everything. It also, like I had mentioned, it doesn't automatically file in your local filing location. So if you're a borough council member in El County, it could be more helpful. There are other limitations with the system, but in some discussions they've had with Sean Firestein, our IT staff, we had considered doing an upgrade to that online filing system. And so we explored some procurement options. One option was there's a current statewide contract with a company called Sapient. They had redesigned the state's websites, the executive branch's websites. They did a very good job. I was very happy with the people that we worked with and their capabilities in upgrading all of these websites. So they have a statewide contract. This particular purchase could fall within the scope of that contract, meaning that we could cut a purchase order against that contract to hire Sapient to perform this work for us. So we had some communications with them. They provided us with a statement of work, and I provided each of you with a paper copy of it. We just received it last week. So if you take a look at that statement of work, some of the things that the system would do would be allowing filers to create an account. They would use the Keystone login, which has recently been updated to allow Google login as well, so it's easier for people to use. But it would allow filers to create an account and save their information year over year. So when you go next year, it'll automatically be pre-populated. It will allow filers to select their actual filing locations, and it'll allow them to complete their SFI electronically. When they hit submit, the system will automatically route the completed statement of financial interest to, for example, the borough in El County that you've selected. So it'll accomplish that filing through an electronic routing process.
I have a question for you on that.
Yeah.
Would the form, say I wanted to file in Elk County, would go to Elk County, but would it still stay on our system as well?
Yes, so we would have access to it here as well. It would also reduce errors in filing because we can build in error-proof tools. We keep some statistics around what errors are that we see the most. It could create reminders or things like that to avoid those common errors. It would be accessible and mobile friendly, so it'll be people who have, that need accessibility, have accessibility issues. We would make these more accessible for them to review, and you could do it on your cell phone if you wanted to. And it would allow for easy public searching for statements of financial interest. So that's what this would do. We engaged in cost negotiations with them. The latest cost that they proposed was $250,800 for the pilot phase. Now, I don't recommend that we do this and go statewide in year one because we're gonna have failures in it. I mean, we would be building a new system. I think we should expect some failures. So what I would propose would be that we do 1 year with a pilot with a handful of municipalities that we select or we request that they participate. We learn where the bugs are, what needs to be fixed, and then only in the subsequent filing year would we open it up to every filer who wanted to use the form. I'm also not proposing that we eliminate the paper forms. I think there's some people that want to use paper forms, so we don't need to eliminate it. This would just replace the online filing that we currently have. We're anticipating sufficient funds to cover this with our anticipated surplus for this fiscal year. We have the money to cover it, but given that this is such a large purchase and will have such a large impact, I wanted to present it to you for your input and your approval. Yes.
So you mentioned cost of pilot program. what about year 2, year 3? What are the anticipated costs and how would we pay for those?
Excellent question, sorry that I missed it. The cost in the subsequent year would be $50,000 is what they anticipated to go from the pilot phase into the full phase. And that's assuming that we don't have like wholesale changes that need to be completed. This will be billed on like a time and materials. $250,000 is the cap before we would have to go and renegotiate the scope and the payment. But it would be, they're anticipating it would be about $50,000.
And would we save any money on our existing systems that we would not have to pay in future years if we adopted this? Or do we know?
I don't know the answer to that question, so that would be a question for Sean.
We'd have to maintain the current systems for a number of years. We have to maintain those statements of financial interest for, I believe, 5 years. So we still have to maintain that system for at least 5 years.
Okay.
Any other questions? Yes.
If we move all of this online, understanding we already have some of it online, do we have any cybersecurity concerns that we have insurance for cybersecurity related risks or anything? We're now asking people to paper.
So I don't know the exact answer to that question. This purchase would be done under a existing statewide contract that's already been negotiated with the Office of Administration and their IT team. So they are required to go with any IT purchase. They're required to receive approvals, including IT security approvals through that process. I'm not an expert in IT security, but I guess I'm presuming that they would have gone through that process. Otherwise, the contract itself wouldn't have been approved. In terms of our own personal security issues, I don't know, Sean. Would you have concerns with regard to IT security here, and do we have insurance to cover that?
For that particular application, the application that Publicis will build is built on top of the current system that the governor's office and all the other state agencies are using for their website infrastructure.
Any other questions?
You're seeking a motion to approve the
Yes,
purchase?
I am.
Okay, I will move to approve the purchase that Executive Director Fox has proposed.
Second.
Second. Any questions, further questions about it? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Thank you very much. I'm excited about this purchase because I think it helps our staff. I think it's going to make these important transparency requirements more easily accessible. And I think it's gonna help all filers across Pennsylvania, and it's just something I think is a valuable way to spend the surplus that we're projecting. So thank you for your approval. The final item on the agenda is our a budget letter. So our practice has been for many years to draft and mail out a letter to members of the appropriations committees in the Senate and the House, as well as the leadership in the Senate and the House, justifying and explaining why we're asking for the budget that we have already asked for, and that we sent that letter out to all of those individuals, and then seek to set up meetings to answer any questions or provide any input that they'd like with regard to our budget request for next year. And so I have included with the meeting materials a draft letter, and I am seeking your feedback and your ultimate approval to finish this letter and then send it out, and then start trying to schedule some meetings to discuss our budget request. Does anyone have comments or questions about the letter itself?
I would have one comment, maybe a suggestion on the next to the last paragraph of the letter, where you get into some of our operational and personnel expenses. Maybe we could add something to show that, we are fiscally responsible and that, we have, I think, 20 or 21 employees now, and our full complement, I think, at one time was 28, so that we're keeping we're trying to be conservative in our approach and we're not going overboard with hiring.
So I'm not certain what our total complement is, the staff member that would know that is out on leave, but I think that we can include language, and I can draft some language that mentions something like we're within our authorized complement in terms of our staffing, maybe more generally.
Yeah, that would be great.
And then if there's specific questions that come up during these meetings, at that point, we should have the answer.
Sure. Yeah, that's great. Thank you.
That makes sense.
Okay,
Good.
all right,
Otherwise, that looks good.
wonderful, thank you.
Very good.
Do we need a motion for that? I don't know that we need a motion.
I don't think we do. You
Okay.
can circulate and
All right.
I think we will all sign it.
Great, and if, we'll make those changes here shortly, and if before you leave, we can get this finalized and
Yes.
everyone's signature on it, so we can get that sent out. All right.
So before we adjourn, we have public comment. Anyone from the public is welcome to make comment to us. Seeing no public comment, I will entertain a motion to adjourn the public meeting.
So moved.
Second,
That.
all in favor? Aye. The public meeting is hereby adjourned. I see it is 10:32. How about we stand in recess till 10:40? And I promise Mr. Redcliffe that he will make his flight to the great state of Texas this afternoon.
Oh, okay.